testimony will be able to the truth, the whole truth, and nothing but the truth, so help you God?
I will.
If you please have your name, spell, and title for the record.
My name is Gary Lammers, Lammers. I am the elected county prosecuting attorney for Putnam County, Ohio, since beginning in January term of 2005. I'll just make some comments or general statements. It's been my experience as being the county prosecutor over this period of time, commencing in 2005, that indeed the Putnam County Board of Elections has had its share of difficulties within that time frame, and even prior to, having been a lifelong resident of Putnam County, a voter, and an individual who lives and works there. I know that there have been issues prior to this board's tenure, that there were errors made in the instance of leaving uncontested candidates off the ballot at an election. Subsequently, we had the special election for the replacement of Senator Gilmore that ultimately led to the board being placed on administrative oversight. Then, within a year or so after that, the office and personnel had to deal with a 100-year flood that struck the community and caused significant disruption and loss to that office in the form of various voting machines and the like. So the office has been through a very tumultuous period of time leading up to this and through this process. Ultimately, this lawsuit, which came to light during the course of being on administrative oversight, a defense was put up. We raised various defenses. The original complaint, I think, alleged up to the best of my recollection, approximately 280-something violations of various instances of sunshine law. Unfortunately, after reviewing the record, going back through the depositions and the testimony that was presented, the case ultimately was submitted on the briefs and the record that was presented. Judge Walters, sitting by special assignment in that case, made his findings, which we take very serious, and as Mr. Kuhlman acknowledged, they take responsibility for it, because despite how the meetings were set up or conducted in the past, they ultimately are the ones who are conducting the meetings and have a certain responsibility to see that those requirements are properly met. However, I think if you would review the record and had the opportunity to get into the full guts of the case, if you will, the details and facts of the case, we come down to 17 violations out of alleged 280 plus. Now, it just takes one violation and one is serious enough, and we do not demean the 17 that are found. But yet, the vast majority, if not all of those findings that the court made, the executive session laws cited by Judge Walters were technical and made in good faith. He acknowledged that the arguments that were made, that the materials that were provided in the training that was provided to the board members was limited at best, and referenced reasons to go into executive session, but yet categorized them with main headings, in this particular case, personnel, with not much elaboration after that fact. Conversely, under the case law, those separate 8 violations were condensed into one violation. And so the judge, because it was a repetitive act under case law, the sanction was over $500 for that technical violation, even though there may have been 8 separate violations. The notice violations, I think are more should be the focus, and are a focus for the Secretary of State, and are a concern not only to me but to the board as well. Unfortunately, they put a significant amount of reliance upon their director and deputy director in ensuring that notices were properly made and rendered. But again, they also now recognize that it's their job in conducting the meetings that notices are properly met. As to some of those various violations of notice, the one violation that occurred on March 3rd was as a result of an emergency situation. One of the previously appointed workers had a death in the family and was called away. They were at the scheduled meeting that day when that came to light. So they're already meeting at that time. And at that point, the director then recommended her spouse to be the replacement for that individual. I don't think anyone or the judge would acknowledge that it wasn't an emergency situation. You're less than 15 hours or so from the actual opening of the polls the next day. Would a phone call have made a difference to the media? The media probably was already sitting there at the meeting. But nevertheless, the phone call wasn't made. So the judge made a technical finding violation. The July 2nd and 14 violations that the court found, the notice put forth and published prior to the meetings indicated that they were carrying over topics from the preceding meeting. So at least some effort was made to give some level of notice. Perhaps it was too vague and ambiguous, but and as a result, the court made a finding that that notice was insufficient. But again, it goes to show that there was no maliciousness, ill will, or malintent to hide or necessarily deceive anyone, let alone the public, for these types of violations. But yet, technically, they probably do constitute a violation.